Good afternoon. My name is Gary McDowell, and with my colleague Terry Price, and I'm the co-director of the John Marshall International Center for the Study of Statesmanship. And it's my pleasure to welcome you to our concluding lecture in this year's series. Each year, this concluding lecture serves as a bridge to a faculty seminar that will follow for the next 2 days. And we've been doing this for 5 years. We've done Shakespeare, we've done Benjamin Franklin, we've done Adam Smith, and we finally get to the point. We figured that sooner or later you have to do John Marshall, and we couldn't be happier with today's program. I won't read you all his accomplishments. They're included in the mailings you received. But our speaker today is Professor Kent Newmyer, who is Professor of Law and History at the University of Connecticut School of Law. He is the award-winning author of several important books: Supreme Court Justice Joseph Story, Statesman of the Old Republic; John Marshall and the Heroic Age of the Supreme Court; and most recently, The Treason Trial of Aaron Burr, Law, Politics, and the Character Wars of the New Nation. Perhaps in questions we can ask him about the character wars of the present nation, but go from there. I would be remiss if I didn't thank, in the first instance, Thomas W. Smith Foundation for their generous support of the John Marshall Center and its programs such as this. We are most appreciative of what they do to make these things happen. With that, Kent, thank you for being with us.
Gary, thank you so much for the invitation, and it's a great honor to be here in Richmond again, talking about your favorite hometown boy. I should say that the audience here, I know, is a formidable audience and not just a little bit intimidating. I'm talking about John Marshall, but I'm looking out here and I see that there are some serious John Marshall scholars in your midst out there. Bob Faulkner is one of them. Back in 1968, Bob wrote a book called The Jurisprudence of John Marshall, which is still a fine and enlightening book. And of course, a lot of you probably know Chuck Hobson, my friend Chuck. Chuck is the editor of the John Marshall Papers. As you know, he's just finished that project, and now he has completed another editorial project, the legal papers of St. George Tucker. You know, any of us who've tried to understand John Marshall have gone to Chuck for help, because he actually knows more about John Marshall than anybody around, and he's always come through with the most generous and helpful remarks. And so in addition to being a great editor, he's a great scholar and a great help. So Chuck, thank you. Also, along the way, I'm going to be bold enough to talk a little bit about the intent of the framers. And of course, when I do that, I'm going to be entering the domain of Gary McDowell, who occupies that territory with great distinction. Actually, I was planning to call my remarks John Marshall Present at the Creation. And I recalled some time ago, maybe 3 or 4 years ago, when I was here in Richmond, I gave a short paper on Marshall. And during the question and answer period, a very informed and pretty irate guy got up and he said, "I just wanted to remind you that John Marshall was not God." So I thought I'd drop the creation business from my title. And I'm hoping somebody in the question and answer period will ask me what the meaning of the lost world of John Marshall is. I think I could perhaps explain that. Well, to locate Marshall here on earth, I thought I would refer to Oliver Wendell Holmes's famous speech in 1901, commemorating the 100th anniversary of Marshall's assumption of duties as Chief Justice. And in his much-quoted remarks, Holmes conceded that Marshall was the representative figure in American law. But no sooner did he say that, than he proceeded to qualify his praise by noting that Marshall's greatness consisted in his simply being there. And he added that Marshall had nothing original to say beyond what the framers and Alexander Hamilton had already said. As Bob Faulkner's marvelous, insightful essay on Marshall and Holmes noted many years ago, Holmes's remarks said as much or more about Holmes than about Marshall. And yet, Holmes was a serious historian, and he certainly spoke to historians by calling attention to the centrality of historical context, being there, that is to say, in explaining Marshall's greatness. So I would like to take Holmes's remarks, what he said, and perhaps even more important, what he didn't say, as my point of departure tonight. Holmes never really fully explained what being there meant. What he mainly had in mind, I think, was the fact that Marshall, as a first-generation interpreter of the Constitution, had the good fortune of establishing constitutional precedents rather than following them. Marshall's famous opinions come to mind in this regard, don't they? I mean, Marbury versus Madison, Judicial Review, so the story goes, Fletcher versus Peck in 1810, on the Contract Clause, which established what one leading historian called the basic doctrine of American constitutional law, McCulloch versus Maryland in 1819, perhaps this was Marshall's greatest opinion, much misunderstood doctrine of implied powers, Dartmouth College versus Woodward 1819, which extended the Contract Clause to corporations, which I think I'm right in saying was not something which the framers had on their mind. Marshall's expansive definition of the Commerce Clause in Gibbons, and of course the great case of Coens versus Virginia, 1821, completed the, what you might call the foundational doctrines of constitutional nationalism. Our courts have cited these opinions literally thousands of times, and they still continue to do so. So after more than 2 centuries, Marshall still participates actively, you might say, in our constitutional discourse. You can't say that about very many presidents, can you? Marshall's constitutional nationalism, I hasten to add, had little to do with our modern bureaucratic regulatory state, even though his opinions are regularly cited as authorizing big government. But neither was his constitutional jurisprudence supportive of laissez-faire economics. Rather, Marshall empowered Congress to create an economic environment which was designed to release the creative energy of individuals. Economic self-interest operating in a national market, transcending sectional divisions, and protected from state interference, Marshall thought, would settle the new nation on a firm foundation. In this nation-building enterprise, originality, something which, by the way, was very dear to Holmes, was not an issue. Indeed, originality would probably have been a fatal mistake. As a common lawyer, Marshall had no interest in pioneering new legal ideas. His legal world, whether he was writing circuit or presiding over the court in Washington, was a pragmatic, workaday world. The overwhelming portion of the Supreme Court's work at that time was of a common law nature concerning property of one sort or another. And the relatively few constitutional decisions that did make their way to the Supreme Court, most came from the state court under Section 25 jurisdiction of the Judiciary Act of 1789. Most of these state court decisions that made their way up to the court concerned economic questions brought by parties engaged in business and commerce. And for better or worse, the dynamic sectors of the economy made the most demands on the law and on the courts. Witness, for example, the litigation regarding the First and Second Bank United States. And by the way, the Bank of the United States had a monopoly on all the great lawyers on that age. You know, William Wirt, one of Richmond's great lawyers, Horace Binney, John Sargent, Daniel Webster, you name them, all worked for the Bank of the United States. Well, speaking of historical context, Marshall's nationalist decisions of the Golden Age were in perfect sync with a short-lived post-War of 1812 period of American nationalism. As Chief Justice, of course, Marshall did not create this nationalism or theorize or philosophize about it. Instead, he and his colleagues seized the moment to facilitate the commercial revolution the American people had already set in motion. Inventors like Robert Fulton, whose steamboat paved the way for the contest between rival steamboat lines, which led to the great case of Gibbons versus Ogden, or businessmen like the Massachusetts textile manufacturers who needed and got a new form of business organization, which the court obliged them with. Law could energize human creativity, but as Willard Hearst taught us many years ago, law was not a substitute for creativity. In facilitating economic nationalism, Marshall was persuaded that he was following the intent of the framers, and I think he was. In its nation-building objective, I might add, the Constitution was a radical document, a document overlaying a deep-seated local culture, or as a matter of fact, many diverse local cultures. In implementing it, ironically, Marshall's court became an instrument of transformative change. Marshall the Burghian had first to create a tradition before he could approach it with trembling and reverence, which is what Burgh urged his readers to do. Concerning the intent of the framers, there was one unique advantage of Marshall's being there, one not mentioned by Holmes. The great advantage that Marshall and his colleagues had, one that no other generation of Supreme Court justices had, was that they were being asked to settle the same nation-defining political economic questions that had been addressed by those that framed the Constitution. No Supreme Court after the Civil War has been asked to defend the Constitution itself or to define the American nation, the underlying themes of antebellum constitutional history. This is not, of course, to argue that Marshall and his colleagues had no interpretive leeway in interpreting the Constitution, but rather that there was a natural connection between the court and the Philadelphia Convention, what you might call a shared interpretive universe. In his opinions and in his role as Chief Justice, Marshall came to personify this connection between the Supreme Court and the written Constitution. Ralph Waldo Emerson once remarked that, quote, an institution is the lengthened shadow of one man. I mean, he could have been talking about John Marshall and the Supreme Court. To focus on Marshall's famous nation-building decisions, however, is to get ahead of the story. The question I think that wants an answer is how was it in the first place that Marshall and the court got married to the Constitution, got to protect it, got to say what it meant? And how, we might ask, as Thomas Jefferson and Spencer wrote, most assuredly did ask, how was it that Marshall himself got to speak so often in the court's great constitutional decisions? Well, the answer to these questions, I suggest, is to be found in a much less celebrated period of the court's history, one in which Marshall himself was discovering what it meant to be Chief Justice and discovering what role the federal judiciary itself should play in the government of the new nation. To locate Marshall in his own age and to determine why it was important that it was Marshall who was there, let me turn to a 4-year period in the court's history, bracketed by the famous case of Marbury versus Madison in 1803 and the treason trial of Aaron Burr in 1807. Except for what Marshall and his colleagues accomplished during this period, the so-called Golden Age, I think, would never have happened. Indeed, one could argue that the 4 chaotic and uncertain years from 1803 to 1807 was perhaps the most decisive period in the history of the federal judiciary. During this period, Marshall also demonstrated, I think, the qualities of leadership that would define his Chief Justiceship. To explore Marshall's symbiotic connection to this formative period and this fluid period in American judicial history, let me be so bold as to revisit Marbury versus Madison, the best known and perhaps the most misunderstood of Marshall's great opinions. Sandy Levinson is a professor, some of you probably recognize the name, professor of law at the University of Texas, and Sandy Levinson wrote an article a while back and says, I'm never going to teach Marbury versus Madison. And of course that's a heretical thing to say. And then he said, well, I'll never teach Marbury versus Madison unless I have a whole semester to teach it. So hey, so I'm going to talk about it in 3 or 4 minutes. Well, of course, that opinion is associated, isn't it, with the Supreme Court's authority to declare acts of unconstitutional. And of course, it links Marshall with Marbury, with judicial review in all of the textbooks and perhaps all of the law school case books as well. Some rethinking, however, has been going on. Many legal historians, I believe it's fair to say, are uneasy with what you might call the single-strike heroic vision of the story. That is to say that Marshall somehow created judicial review In one dramatic pronouncement in Marbury, the famous quote, "It is emphatically the province and duty of the judicial department to say what the law is." Recent scholarship has unearthed dozens of examples, in fact, of judicial review as it operated at the state level before Marbury versus Madison. And here in Virginia, most conspicuously with St. George Tucker leading the way. And this, of course, is not to mention the higher law background of judicial review, the English legacy, Hamilton's famous Federalist 78, or the occasions before Marbury when the Supreme Court itself heard cases regarding the constitutionality of federal statutes but upheld them. So, let me suggest that we look at Marbury not as creating judicial review, but rather as a contest with the executive branch to keep and reaffirm the authority the court was already widely assumed to possess. So judicial independence, I would say, indeed, I think judicial survival, was the overarching issue in 1803. In its struggle with the political branches, the federal judiciary, and especially the Supreme Court and Marshall, had a steep hill to climb. The court's elite and secretive mode of operation, its non-elective character, life tenure, all of these things were encountered to the democratic, anti-aristocratic character of that age. What the court had going for it institutionally was that it got its own separate article in the Constitution, Article 3, a fact that theoretically at least put it on a par with the legislative and executive branches, and also which gave the court the same organic relationship to the sovereign people as the political branches. Marshall understood the court's vulnerability, but he also understood the potentially strategic position in the architecture of the Constitution, a position he was determined to make the most of. The written Constitution, then, was the court's shield and buckler. Textual exegesis was Marshall's forte. Working out the implications of Article 3, of course, brought him into direct conflict with President Jefferson, who hated Marshall personally, who distrusted federal judicial authority generally, and of course, whose party controlled both houses of Congress. In Marshall's struggle with the president and his party, it should be emphasized that the political branches had not yet established their own internal working procedures, nor had the president and Congress worked out their relationship with each other or with the sovereign people. Simply put, then, constitutional government during this period was a work in progress, with all that signified for the importance of leadership, strategic savvy, and personal character. Seen as a battle in the War of the Branches, Marshall's opinion in Marbury assumes a different cast, I think, especially as it concerns the argument about judicial review. If judicial review was a commonly accepted notion, then Marshall did not have to finesse the case, which is assumed by many was what he did. He did not have to finesse the case in order to create the principle, as has been charged. He did, however, have to finesse, strategize in order to keep the court from being humbled by a president who wanted to do just that. In this light, then, the personal dust-up in the case of Marbury between Jefferson and the Chief Justice turns out to be the central feature of the case and not just a political sideshow. Marshall has been criticized, as some of you know, for manipulating the case, by example, for calling on his brother to testify to the existence of the disputed commissions, and of course he has been accused of lecturing the president, giving the president a law and order lecture. Very cheeky, for sure, especially since Marshall then went on to say that the court had no jurisdiction and therefore no authority to say what he just said. It must not be forgotten, however, when you're looking at this, that the president was out to humble the court. Everybody knew that. And to, as he said in one of his letters, one of Jefferson's letters, to eradicate the spirit of Marshallism. As for Marbury, Jefferson politicized the case from the outset by stonewalling the proceedings, by refusing to permit the lawyers for the government to argue the case, by prohibiting officials from the State Department from testifying as to the very existence of the commissions, which, had he succeeded, would have stopped the litigation in its tracks. So, as a separation of powers matter, Marshall and Marbury set out to establish the court's Article 3 character as a legal institution distinct from, equal to, the elected branches. Thus, his meticulous effort in this case to distinguish between the president's political authority to make the appointments to the justices of the peace for the District of Columbia and the court's judicial obligation to interpret the legal meaning of the commissions once they were issued. And to prove that a commission of office once granted was a vested right that the court was obliged to uphold, Marshall turned to the common law. In fact, common law thinking, common law language, common law doctrine infused Marshall's entire opinion in Marbury. And this brings me to a major point about Marshall in the context of his age. It's been standard wisdom, thanks to Hamilton's famous Federalist 78, to assume that the federal judiciary was the weakest of the three branches, the least dangerous, as the word goes. Because it had no access to the purse, it depended on the president, was vulnerable to congressional action, and so on. What Hamilton didn't mention, however, was that in this turf war between the court and the political branches, and in the court's struggle to define itself, the court, thanks to the taught tradition of the common law, already had an institutional sense of itself, a special language, a well-known body of rules and doctrines. When Article III granted the federal judicial authority in terms of cases and controversies, it called forth an institutional history and an interpretive tradition that was centuries old. Marshall called on that legacy in Marbury. In none of his other great opinions, with the exception, I think, of United States versus Burgh, was common law reasoning, common law terminology so pervasive. Thus it was that Marshall went on for several pages to explain the ancient common law writ of Mandamus. His famous paragraph about judicial review, as Robert Clinton has reminded us some time back, came directly from Sir William Blackstone's commentaries, his 10th rule of statutory construction, almost word for word. Marshall's notion about the property nature of the office, as noted, was rooted in common law. All this came naturally because Marshall was a gifted common lawyer before he became a great Chief Justice. Reading the whole sprawling, untidy opinion in Marbury, including the pretrial stuff that went on in 1801, actually something which I think modern students rarely do, reminds us that the man who projected the Supreme Court into the modern age still had one foot in the 18th century cisatlantic world. Does this make Marshall an advance guard of the Enlightenment thinking? You guys tell me. I think it's a good question. To fully appreciate the importance of Marshall's common law heritage in his struggle with Jefferson, consider that nobody at that time was quite sure what the American presidency should look like. Obviously, the British monarchy was no model, and Washington's unique imprint on that institution was, I guess you might say, an impossible act to follow. So in dealing with Marshall and the Supreme Court, and with much else, including above all the treason trial of Aaron Burr, President Jefferson personalized the office of the presidency. With no institutional tradition to guide and restrain him, Jefferson felt justified in relying on his own instincts and on his assumption that he and the sovereign American people just happened to be one and the same. And this was precisely the point, by the way, that Burr's lawyers turned against Jefferson in the Burr treason trial. Now, let me jump ahead a little bit and quote one of those lawyers. The lawyer who delivered this message in a, what you might call a distinctly American idiom, was Luther Martin of Maryland. Old brandy bottle, they called him, I guess for obvious reasons, and also they called him Old Law Ledger because he was probably the finest trial lawyer in America. I had a feeling that maybe he might have had a snort or two when he upbraided Jefferson's lawyers in this trial for presenting the president, as he said, as some kind of sovereign. Mind you, this is the author of the Declaration of Independence he's talking about, or as the King of Great Britain, or worse yet, as the supreme being himself. Jefferson read this, wrote a note to his lawyer suggesting that Marshall himself might be impeached for misprision, the concealment of treason. Things that were very personal in those days. and never more so than between Jefferson and Marshall. In Marbury, then, Marshall's first head-to-head, you might say, with Jefferson in the separation of powers war. The Burgh treason trial in 1807 here in Richmond was the second. The Burgh trial was notable for many reasons, starting with the fact that the former vice president was in the dock of Marshall's circuit court, accused by President Jefferson of being a traitor for trying to separate the western states from the Union. Attention-getting the trial certainly was. The proceedings lasted 7 months here in Richmond during one of the hottest summers on record. It involved some of the most gifted lawyers in the country, most of whom were Virginians, and actually many of them from Richmond. The trial received unprecedented coverage in the nation's partisan press, with the Richmond Enquirer providing most of the copy. Edward Corwin called it the greatest criminal trial in American history. The Burgh trial was also one of the most significant and the most personal showdowns in American history between the executive branch of the government, as represented by Jefferson, and the federal judiciary, as represented by Chief Justice, sitting this time as a trial judge here in Richmond. As such, the Burgh trial was a continuation, I argue, of Marbury versus Madison. Jefferson saw it that way, and so did Marshall. What brought these two Virginians and the two branches of government they represented head-to-head here in Richmond was Jefferson's announcement to the nation on January 22nd, 1807, that his former vice president was guilty of treason. This, without benefit of a grand jury indictment or obviously a jury trial. And in addition, and that's another unique happening in American history, the president undertook to micromanage the prosecution here in Richmond from the White House, instructing George Hay, who was the federal prosecuting attorney, about witnesses, evidence, and litigation strategy, you name it. The president even sent Hay a batch of blank pardons to elicit testimony from reluctant witnesses. So Jefferson was the elephant, you might say, in Marshall's courtroom, even though he wasn't there in person. Still smarting over Marbury, the president was convinced that Marshall would manipulate the law in order to free Burgh, in order to embarrass him yet once again. Before the trial was over, Jefferson was as much interested in getting Marshall impeached as he was in getting Burgh convicted. And in fact, one of his many orders to George Hay was to build a paper trail against Marshall to be used in impeachment proceedings. Marshall understood full well, as did his enemies, that as a trial judge, he had no place to hide. Marshall also fully appreciated the high stakes in this trial. Burr's life, of course, was on the line, Marshall's own job and reputation, and finally, perhaps most importantly, the future status of the federal judiciary as an equal branch of government. Jefferson seemingly held all the cards. His party controlled both houses of Congress, and the American people were on his side. Most of them, including the jury pool here in Richmond, were certain that Burgh was the traitor that the president accused him of being. This is to say that a fair trial for Burgh pitted Marshall against public opinion, whipped up by a popular president. And before the trial ended, the partisan press branded Marshall himself as a traitor. After Burgh was acquitted, the mob in Baltimore hanged him in effigy. Jefferson's determination to impeach Marshall says a lot about Jefferson. His failure to do so says a lot about Marshall. So why did Jefferson fail? Henry Adams, in his Great History of the Period, said that Jefferson's impeachment campaign would have succeeded had it not been for the Chesapeake Leopard affair, which happened right during the middle of the Burgh treason trial, and of course the threat of war with England. Perhaps this is true, but I would argue that Marshall's survival in the trial, his victory really, was due primarily to the qualities of judicial statesmanship he manifested in the trial, as a trial judge and as a judicial lawmaker. The story is complicated, but it comes down first of all to the fact, as is evidenced in over 1,000 pages of stenographic trial transcript, that Marshall saw to it that Burgh got a fair trial. And this, after all, was the overriding issue. To grant Burgh a fair trial, Marshall had to resist popular sentiment that had prejudged Burgh guilty, but Marshall also had, as he admitted, to resist the personal temptation to give in to public opinion to save his own hide. Beyond that, Marshall had to keep order in the court during the long, hot summer as counsel on both sides became passionate and personally insulting to one another and, of course, to Marshall himself. He let both sides have their say, and no doubt he let them ramble on longer than he should have, and they played to the galleries much too often, for sure. But Marshall listened and learned from the remarkably brilliant arguments, because this is what common law judges did. In his 15 opinions and rulings made on the spot, he settled the basic rules of criminal procedure that gave substance to the fair trial requirements of Article 6 of the Constitution. And in the process of deciding what evidence the jury could legally consider, Marshall settled the meaning of treason in Article 3, Section 3 of the Constitution, defining it narrowly so that future presidents would find it difficult to use treason prosecutions to silence political dissent and eliminate political opposition. My point in all this is that Marshall's performance as a trial judge in a criminal trial was in fact a decisive constitutional moment, a desperately needed victory for independence and reputation of the federal judiciary itself. He was educating the jury, the spectators in the old State House, the tens of thousands of people across the nation who read the newspaper accounts of the trial. By defying public hysteria, Marshall demonstrated to the American people why they should voluntarily agree to be restrained by a non-elective, non-democratic court of law armed only with the mantle of due process. Marshall was not alone in this undertaking. As he acknowledged many times during the trial, he was indebted to the remarkable lawyers in the case who parsed several centuries of Anglo-American law for his consideration. Marshall was a great listener and a quick learner, and he educated himself by listening. But because he had traversed the same ground, he knew how to pick and choose wisely, how to put his own imprimatur on the final product. Marshall's being there made all the difference. So to fend off the president's attack on the court, Marshall circled the wagons, you might say, around the rule of law, the heart of which was the procedural rights of criminal defendants. The pivotal due process moment, you might say, in the trial came on June 13th when, at Burgh's request, Marshall issued a subpoena duces tecum to the president, sitting president, Thomas Jefferson, ordering him to produce papers in his possession that Burgh needed to prepare his defense. In issuing the subpoena, which gave Jefferson one more reason to impeach him, Marshall took the occasion, as in Marbury, to define passionately and to defend the court's legal obligation and his judicial duty to issue the subpoena. The contest over the subpoena, then, was a textbook example of separation of powers in operation. Madison's Federalist 51 being the text. Citing executive privilege, Jefferson, through his lawyers, strenuously objected to Marshall's action, but as it turned out, the president reluctantly delivered most of what Burgh asked for, although Jefferson never conceded that he was legally obliged to do so. Marshall prevailed in the struggle for several reasons. First, he got the documents which Burgh needed for his defense. In the process, he elaborated on the unique and essential role of the federal courts as guardian of constitutional rights for criminal defendants. What sealed Marshall's victory was the fact that his words, unlike those of Jefferson, were preserved as law in the reports of the trial, which meant, of course, that they were available for future use by subsequent courts. Never were Marshall's arguments about the subpoena more appropriate for the necessity, what you might say, of compulsory process in criminal trials more relevant than in the famous Watergate case of United States versus Nixon in 1974. It was entirely appropriate in that case that Chief Justice Warren Burgh should order President Nixon to hand over the infamous tapes, and that the court's decision should rest squarely on Marshall's opinion about the subpoena in United States versus Burgh. Throughout the Burgh trial, Marshall based his action, as he repeatedly called, on judicial duty, which, by the way, is a much more inclusive, maybe importantly interpretive concept than judicial review, and one certainly which can be traced back centuries in English law. As Marshall reasoned, judicial duty imposed by his oath of office was a sworn duty to dispense justice and to govern fairly. And isn't it true? Judges govern. They govern differently than legislators and presidents, of course, but they govern nonetheless. Sometimes they also make law. And sometimes what they do when they govern rises to the level of statesmanship. Well, Marshall made some statesmanlike Republican law in the Burgh trial. He also accomplished two immensely important things during this 4-year period we've been considering. First, he managed not to get impeached, which, had it happened, certainly would have altered the course of American constitutional history. A Supreme Court headed by Jefferson's favorite Spencer Roane would have looked vastly different. The great decisions of the Golden Age would not have gone down as they did. You know, sometimes what doesn't happen in history is actually more important than what does happen. The second of Marshall's accomplishments during this early period exceeds all others in its far-reaching consequences. By dint of character and political savvy, and I'd say wisdom, Marshall persuaded his colleagues on the court to abandon the practice of writing separate opinions in favor of a single majority opinion. If the court was to be the chief interpreter of the Constitution, which after all is the real meaning of judicial review, right? It needed to speak in a single institutional voice. This silent revolution in the way the court did its business laid the institutional foundations, not just for the Marshall Court decisions, but for all future decisions of the Supreme Court of the United States. By the way, Jefferson tried to reintroduce seriatim opinions in the 1820s, but fortunately he failed. In effecting this fundamental change, interestingly enough, Marshall did not rely on English practice, but rather repudiated it. Marshall's success in unifying the court marked him as a pragmatic, tough-minded political strategist, the same qualities we see, as a matter of fact, in Marbury and in the Burgh trial. He knew the strengths and weaknesses of his colleagues and of his enemies. He knew when to hold, when to back off, when to strike back. As a field commander, you might say, in the campaign of history, this is a phrase from Holmes's famous speech, Marshall actually used, I think, Jefferson's attack on the court to rally his own troops, that is to say his own colleagues on the Supreme Court, and to unify his own command. Like his hero Washington, the greatest man in the world. Chuck can tell me what that letter was. I think it was in 1780. And of course, Marshall was just finishing up this monumental biography of Washington. Actually came out, I think, maybe the last volume, maybe during the trial. There was a connection, it seems to me, between Marshall's behavior on the court and Washington's behavior as a general in the Revolution. Marshall realized that when the other side had the numbers and the heavy guns, he should consolidate his interior lines of defense, avoid direct confrontation with the enemy, unless, of course, one commanded the high ground. And the ground doesn't get much higher, does it, than due process when a man's life's on the line. Well, scholars seeking to account for Marshall's accomplishments as Chief Justice rightly emphasize his remarkable legal mind. But character, it seems to me, was hardly less important. His knowledge of human nature, his ability to inspire trust, to quiet or at least contain competing egos on the court, to harness the diverse talents of his colleagues into the collective enterprise of judicial governance. In an age when personal honor counted heavily, when everybody knew everybody else, it mattered greatly that Marshall was a man of proven integrity with a natural-born sense of decency. He never doubted his ability, but he carried his genius humbly. On the matter of Marshall's character, let me, in conclusion, call a couple of witnesses to the bar, you might say. One of these witnesses is Jared Sparks. Jared Sparks was Washington's biographer and a future president of Harvard. And Sparks visited Marshall here in Richmond, visited at his home in April of 1826. And Sparks came away in awe of Marshall's Republican personality, the blending into a consistent whole, as Sparks put it, of all things about him: his house, his grounds, his office, himself, and how they all bear the marks of a primitive simplicity rarely seen combined. I was talking last night, we had supper, Gary and some friends, and it seems to me that architecture is sometimes a clue to personality. I've often thought a comparison of Marshall's simple but elegant Federal House here on Marshall Street to Jefferson's Monticello says a huge amount about the immense differences between those two cousins. Well, Sparks probably, I think, would have been astonished to have seen Marshall whooping it up with his friends in the barbecue club, or had he seen the Chief Justice of the United States down on all fours, measuring a disputed quoit tossed with a straw. I think Lincoln, who resembled Marshall in so many ways, might have been seen doing that, but I can't imagine George Washington doing it, or maybe Hamilton or Thomas Jefferson either. Marshall, the Burkean conservative who felt the people needed to be restrained by law, was himself a man of the people. My second witness is William Wirt, who's my favorite Richmond lawyer. Even though he lost the case of the Burgh treason trial, Wirt was a great man, a great lawyer, argued more cases before the Marshall court than any other lawyer. He summed up Marshall simply in a letter to his friend Dabney Carr in 1827 when Wirt said that there was not a better-natured man in the world than the old chief, and a more powerful mind was scarcely ever sent upon this earth. Well, Marshall wanted to be remembered by his friends and family, so he sat patiently for his artists who painted his portraits. On the other hand, as Chuck can tell you here, he was pretty casual about preserving his papers for posterity, and in fact, he burned many of them. Unlike so many other statesmen from this generation, Marshall didn't seem at all interested in being a founding father. Although the man who put the Constitution and the nation on a firm foundation surely qualifies for that honor. What the historian Thomas Babington Macaulay said of John Hampden strikes me as being equally true of John Marshall. He was, to quote, an almost solitary instance of a great man who neither sought nor shunned greatness, who found glory only because glory lay in the plain path of duty. Thank you much.